Check 1, 2.
You guys ready to get started? Okay, all right. I call this legislative hearing to order. Good afternoon. I'd like to welcome you all to the first legislative hearing of the Subcommittee on Disability Assistance and Memorial Affairs for the 116th Congress. As the subcommittee's new chair, I welcome the other new members on both sides of the aisle. I am confident that this subcommittee will continue the bipartisan effort to care for our veterans who have been injured in service to our nation. Thank you to Ranking Member Bost for welcoming me and working with me on today's agenda, which includes 7 bills, one of which we are sponsoring together, H.R. 1200, the Veterans Compensation Cost of Living Adjustment Act of 2019. This bill increases the rate of compensation for veterans with service-connected disabilities and for their survivors who receive dependency and indemnity compensation. The disability compensation rate increase, or COLA, is tied to that which is provided to Social Security recipients under the Social Security Act. The authority required for VA to make this cost of living adjustment to veterans' benefits expires each year and must be extended by December, which is what H.R. 1200 does. The increase for 2019 is 2.8%. I also want to welcome to the dais, I think he'll be here shortly from Votes, Chairman Mark Takano, and Ranking Member Phil Rowe, who are joining us today to advocate on behalf of draft legislation they have agreed to for H.R. 299, the Blue Water Navy Veterans Act of 2019. Thank you also to Representatives Connor Lamb and Julia Brownlee, who I think will also be here shortly, who plan to speak on behalf of the Veterans Valuing Our Widows and Widowers Act, or the Veterans Vow Act. Without objection, Representative Lamb and Representative Brownlee are permitted to sit on the dais at today's hearing. In addition to the COLA Adjustment Act and the Blue Water Navy Vietnam Veterans legislation we will discuss today, we are also taking testimony on H.R. 1199, the VA Website Accessibility Act, which passed the House last Congress but did not make it through the Senate before the end of the 115th Congress. The VA Website Accessibility Act directs the VA Secretary to conduct a study of all veteran-facing websites to ensure they are accessible to veterans with disabilities, particularly those who are visually impaired. This accessibility was guaranteed under the Rehabilitation Act of 1973, but VA is not yet fully compliant. This bipartisan legislation is co-sponsored by my committee colleague, Congressman Banks, and will ensure visually impaired veterans can readily access the benefits they have earned and the care that they deserve. VA should strive to make benefits and services accessible to all veterans, regardless of their disabilities. I have personally heard from two groups of veterans who would benefit from this improvement to the VA websites. I appreciate the Blinded Veterans Association of America for being here today to emphasize this need. I am very proud to introduce this legislation and look forward to hearing the testimony of the VA and veteran service organizations on how it might help improve access to VA benefits for the visually impaired. We will also hear testimony today on H.R. 1826, Mr. Lamb's Veterans Vow Act, which codifies the current rate the special monthly pension Medal of Honor winners receive at $1,329.58 per month. It also allows for payment of this pension to surviving spouses, provided they were married for at least 1 year, or if they were married for less than a year if they became parents of a child. Another bill on the docket today, sponsored by Representative Lamb, H.R. 2385, which was previously announced as a draft bill, provides the authority for the Departments of Veterans Affairs to establish a grant program to conduct cemetery research and produce educational materials for the National Cemetery Administration's Veterans Legacy Program. Currently, VA awards federal contracts for this program, but the institutions of higher learning who most often receive and the largest group of participants in this vital work tell us that working with grants is much more efficient and easier for them to administer. Finally, we will hear more in a minute about H.R. 299, the Blue Water Navy Vietnam Veterans Act, from its sponsor, Chairman Takano, and from Ranking Member Rowe, who shepherded it through the House last Congress unanimously. As the representative of Virginia's 2nd District, which is home to Naval Station Norfolk and several other Navy bases, I am honored to take part in advancing this legislation through this subcommittee. It is my hope that this legislation will make it to the President's desk without delay. This legislation will make Congress's intent clear that Blue Water Navy veterans will receive much needed and deserved compensation and care. Again, I want to thank everyone for being here today. We look forward to your testimony and the answers to our questions. I now recognize our Ranking Member Bost for his opening comments. Mr. Bost, you're recognized for 5 minutes.
Thank you, Chair Luria. It's an honor to be back and as the ranking member of the Subcommittee on Disability Assistance and Memorial Affairs. I want to begin by welcoming Chair Luria and the new members of the subcommittee. I look forward to working with all of you. In the past, this subcommittee has had one overreaching priority, which is to improve benefits and services for our nation's veterans and their families. I've met with Chair Luria, and I am confident that under her leadership, this subcommittee will continue to work in a bipartisan manner on issues affecting the brave men and women who have served in our armed forces. To those who testify on our panels today, thank you for all of you for joining us here today to discuss the important pieces of legislation pending before this subcommittee. These bills are intended to improve the lives of our veterans and their families. One of the most prominent bills on today's agenda is a draft update of H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2019, which would extend the presumption of exposure to herbicides to veterans who served in the offshore waters of Vietnam. Over 100,000 veterans served off the coast of Vietnam. Unfortunately, many of these veterans have been waiting for 40 years to receive recognition from the VA that their illness may have been caused by exposure to Agent Orange. Our Blue Water Navy veterans deserve to qualify for the same benefits as their fellow veterans who served on the ground and in the inland waterways. This bill is long overdue and ensures that Blue Water Navy veterans receive the benefits they've earned. Additionally, this bill would address the concerns of other Vietnam-era veterans, Gulf War veterans, and all of their families, and make improvements to VA home loan programs. I want to thank Ranking Member Rowe for his relentless efforts over the past several years to get this legislation signed into law as quickly as possible. And I'm confident that the Chairman Takano's support, with his support, we will soon be successful at this. Moreover, I'm proud to be the lead co-sponsor with the chair with Bill H.R. 1200, the Veterans Compensation Cost of Living Adjustment Act of 2019. Veterans and their families should not be worried about how they're going to pay their bills when prices go up. H.R. 1200 would help ensure that the value of the veterans' benefits keep pace with inflation by giving veterans a cost of living increase if Social Security recipients receive one this year. I would like to commend one of our freshman members, Mr. Stubbe of Florida, for introducing H.R. 1628. The I'll get this right, Ewnawatok Atoll Cleanup Radiation Study Act. Last Congress, we held a subcommittee roundtable on the cleanup where we heard from DOD, the Nation Academy of Science, and multiple veterans and other stakeholders. Many veterans who participated in the cleanup raised questions at the roundtable about the accuracy of DOD's reports on their radiation exposure. H.R. 1628 would help address their concerns by having the National Academy of Science review DOD's assessment. I believe that these veterans deserve an answer about their alleged exposure, and I hope this bill passes the House very soon. Another bill that has my full support is H.R. 1126, which would allow the VA to mark the name and dates of a deceased spouse on a VA headstone in a private cemetery, just as it does for family members buried in a national cemetery and state cemeteries. My staff has heard numerous concerns from veterans about how VA cannot properly memorialize spouses and dependents who are buried in private cemeteries. I appreciate Mr. Lamalfa's lead on this issue by introducing this common sense legislation that would fix this oversight. I know how many of my colleagues here today have worked hard on their proposals. I look forward to discussing how these bills would impact veterans and their families. With that, I thank you and I yield back.
Thank you, Mr. Boss, for your comments. I now recognize Chairman Takano for his remarks.
Thank you, Madam Chair. First, I want to thank you for including H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2019, in this legislative hearing. Today, I again advocate for this critically important bill. Last Congress, we saw its unanimous passage under the leadership of Chairman Rowe, but unfortunately, it stalled in the Senate. As chairman of the committee in this Congress, the Blue Water Navy Vietnam Veterans Act of 2019 was the very first piece of legislation I introduced. This year, with a new path forward, I'm confident we'll finally see this bill passed into law. I'm delighted that today marks the first meeting of the DAMA subcommittee, whose consistently bipartisan approach sets it apart. Together, Dr. Rowe and I present an updated version of H.R. 299 following the Federal Circuit Court's decision in Procopio. That case reversed VA's 1997 decision to deny the presumption of Agent Orange exposure to veterans who served in the offshore waters of Vietnam. Procopio was a huge step forward, but we need to do more. We need to ensure Blue Water veterans are protected in the event Procopio is appealed to the Supreme Court and overturned. That is why Congress worked together with veteran service organizations to establish, without a doubt, that Blue Water Navy veterans are entitled to this presumption. Our current proposal is very similar to the bill passed last Congress. It includes crucial geo-coordinates that clarify the territory off the coast of Vietnam that VA must recognize when deciding claims for disability compensation for herbicide-related diseases. This proposal is the quickest and clearest route to delivering benefits to these deserving veterans. Additionally, our bill extends the presumption of herbicide exposure to certain veterans of the Korean Demilitarized Zone, easing the pathway to disability benefits for those who developed herbicide-related diseases. Our bill also expands benefits to children with spina bifida of herbicide-exposed Thailand veterans. These comprehensive provisions ensure we deliver essential benefits to those suffering the ill effects of herbicide exposure. Because the majority of DAMA members are new to Congress, it is important that we hold a hearing to reacquaint ourselves with the key issues and hear views on the draft bill. I want to welcome the American Legion, VFW, DAV, Vietnam Veterans of America, and the American Academy of Sciences for being here to help us discuss the important bills in front of us today. Regrettably, VA has chosen not to offer any testimony on H.R. 299 today. The VA has sent a witness to provide views on the 6 other bills on the agenda, but not on H.R. 299. We welcome him, but I would like to make it clear that the agency was asked to send a witness who could testify on its plans for implementing Blue Water. To achieve the best results for veterans, we must have their cooperation going forward. Now, it is regrettable that they are not providing this information to Congress, since it is our obligation to oversee their plans for the implementation of what is now the law of the land. Now, before yielding back, I want to welcome and introduce distinguished Professor Allison Hedgecock of the University of California at Riverside, who has produced some of the best work in the country as a part of VA's Veterans Legacy Program. Her research on the veterans buried in the Riverside National Veterans Cemetery and her creation of teaching curricula for local teachers is remarkable in the energy and in attention it brings to the cemetery. Her students use her educational programs to revitalize the stories of the men and women buried there. I look forward to Professor Hedgecock's testimony on Mr. Lamb's bill, which changes the current Veterans Legacy Project from a federal contract program to a federal grant program. Institutions like UC Riverside tell us that management of grants is administratively easier than the management of contracts for colleges and universities. Now, we want to do whatever we can to encourage the work of academics like Professor Hedgecock, who can help us understand and appreciate the heroism and sacrifices of local service members. So thank you, Professor, for traveling so far to join us today, and I know it's even a longer trip back home. So we very much look forward to hearing from you today. And I yield back, Madam Chair.
Thank you, Chairman Takano. I now recognize Ranking Member Rowe for his statement.
I'd like to thank the chair and ranking member for their leadership on today's legislative hearing, and I'd like to associate my remarks with the chairman. It's no surprise that one of my top priorities as ranking member of this committee is continuing our work on the 115th Congress to ensure that our Blue Water Navy Vietnam veterans receive the benefits they've earned. Last Congress, by a vote of 382 to 0, let me say this again, by a vote of 382 to 0, and literally we probably couldn't agree that the sun came up in the east most days. 382 to 0 is an impressive number that we passed for the Blue Water Navy Vietnam Veterans Act of 2018. Unfortunately, despite the efforts of Senate Veterans Affairs Committee Chairman Isaacson and Ranking Member Tester, the Senate never passed the legislation. This is why one of my first actions at the start of the 116th Congress was to introduce H.R. 203, which mirrors last year's Blue Water Navy bill. Although H.R. 203 is not on today's agenda, I appreciate Chairman Takano's efforts to maintain the momentum this committee made last Congress to enact legislation that would benefit the benefits in health care to our Blue Water Navy veterans. I'm happy to partner with Chairman Takano on H.R. 299 and appreciate his bipartisanship to make sure this time we get the bill across the finish line onto President Trump's desk. I also want to thank all of our VSO partners for their support and help to craft a bill that finally fulfills our nation's promise to these veterans. Recently, Blue Water Navy veterans won big when the Federal Circuit Court ruled in the case of Procopio versus Wilkie that the VA should accept in the waters surrounding the Republic of Vietnam for the Agent Orange presumption, just as VA does for boots on the ground service. I was further encouraged by Secretary Wilkie's recommendation that the Solicitor General not appeal the court's decision. However, at this time, it's unclear how the department plans to interpret the federal court's holding. That's why I believe that passing of H.R. 299 is necessary to ensure that those veterans who were potentially exposed to Agent Orange in the waters offshore of the Republic of Vietnam are guaranteed entitlement to the presumption. Moreover, the package of H.R. 299 not only addresses the plight of Blue Water Navy Vietnam veterans, but also includes provisions that would extend the presumptions to veterans who served in or near the Korean DMZ beginning September 1, 1967. Provide benefits for the children of Thailand veterans who were exposed to Agent Orange, address the concerns of Thailand and Gulf War veterans about their potential in-service toxic exposures, and make improvements to VA's home loan program. I support the draft update of H.R. 299 and hope it passes the House without delay. And with that, Madam Chair, I yield back the balance of my time.
Thank you, Ranking Member Rowe. I now recognize Representative Lamb to provide his testimony on his bills, H.R. 1826, the Veterans Vow Bill, and H.R. 2385 concerning the Legacy Project.
Thank you, Madam Chairwoman. First, as to the Veterans Valuing Our Widows and Widowers Act, or Veterans Vow Act, 1826, we all know that the Medal of Honor represents the highest possible recognition for valor in combat. And currently, in recognition of that, Medal of Honor recipients are entitled to an additional monthly pension. However, when that Medal of Honor recipient passes away, the pension stops. And I think all of us in the veterans community know the important role that our caregivers play for these veterans of all types, but especially for Medal of Honor recipients. They have strenuous public schedules. They're often asked to appear at a lot of events. They really become symbols in our community, and many of their spouses carry a lot of the load for taking care of them, for helping make that possible. So what our bill would do is make sure that that pension continues for the spouse if the veteran does in fact pass away. I believe that all surviving spouses should be eligible to receive these pensions. They are part of the family that made this sacrifice for our nation, and we should recognize them as such. Thank you, and that is my testimony for 1826. Would you like me to move on to the other one as well?
Yes, please
Madam
continue.
Chairwoman, thank you very much. The other bill is H.R. 2385, which we're introducing for the second Congress, the Veterans Legacy Program, and as Chairman Takano noted, we're going to hear some testimony about that today from the folks at Riverside. But this one is just, it's a no-brainer. It's a great bill. This is already an existing program by which we encourage schools, colleges, people in the community to learn about veterans in our veterans cemeteries and publish educational materials about them. It already exists. It's a contracting program, and that's a little bit harder for these institutions than if it was a grant program. Basically, universities and other places, they know the process for getting grants. They're not as familiar with the process for getting contracts. So all we want to do is make that simple change. Near my district, we have the National Cemetery for the Alleghenies, and we already have local schools signed up and ready to go to research each one of these veterans that are buried there. Some of them even envision something like an app that you can have on your phone where you would go to a veterans cemetery, and in front of each headstone, the app could show you who that person was, where they served, and what sacrifice they made. I can't think of anything better to inspire the next generation of kids on their field trips, in their classrooms, to want to be part of the military, to honor the sacrifice that these folks have made. So this is a great program, and we're looking to do everything we can to make it easier to participate.
Would the gentleman
Thank you.
yield?
And I would gladly yield to Dr. Rowe for further explanation.
Thank the gentleman from Pennsylvania. We have a fellow in our, just for information today, a fellow in our office for the next 2 years who is gathering all veterans, living veterans stories. And I explained to him, I said, look, I don't want you to tell me that you won the Korean War single-handedly. I don't want that story, but we're collecting every veteran that will sit down. It'll be digitized and put in the Library of Congress so that 100 years from now or 150 years from now in the future, you can look back digitally and see what your family member or write a history of that. So I would encourage all congressional districts to try to do this with their veterans if they could, and it would create a history that, look, if we had done it 100 years ago, think what we'd have now, the treasure trove of information. Appreciate the gentleman yielding. I yield back.
Thank you, Dr. Rowe, and Madam Chairwoman, I yield back.
Thank you, Representative Lamb. I now recognize Representative Stube, who will offer his testimony on behalf of his bill, H.R. 1628, the Inawak Atoll Cleanup Act.
Thank you, Madam Chair, and thank you for hearing this bill. I appreciate it. From January 1977 through December of 1980, approximately 6,000 American veterans participated in the cleanup for the Inawetak Atoll nuclear testing site at Inawetak Atoll in the Pacific Ocean. The site was home to 43 U.S. nuclear tests from 1948 to 58, and the cleanup was necessary to return the atoll to the trust territory of the Pacific Islands. The Inawetak Atoll cleanup was performed by a joint task force group with the Departments of Defense and Energy, which rehabilitated the area by conducting radiological surveys, removing contaminated soil and debris, demolishing contaminated buildings, transporting contaminated soil and debris to disposal sites, and preparing the area for the return of the inhabitants. In this process, veterans who served at Inawetak Atoll were potentially exposed to dangerous doses of radiation through skin contact, breathing contaminated air, and drinking and bathing in contaminated water. However, there is conflicting scholarship on the subject. In 2018, the Department of Defense conducted a radiation dose assessment and determined that veterans who served in the cleanup were not exposed to harmful levels of radiation, but veterans disagree with the DoD's findings. Last year in a roundtable before this very subcommittee, veterans and scientists cited specific issues with the methodology and the assessment of the DoD's review. The scientists from the National Academies of Sciences, Engineering, and Medicine stated that the DoD's methodology may have been outdated and therefore the DoD's assessment may be inaccurate. Though the DoD has refuted some of these claims, I think we owe it to these veterans to get to the bottom of this, and that's why I've introduced the Inawetak Atoll Cleanup Radiation Study Act, which calls on the Department of Veterans Affairs to partner with the NAS to study the effects of radiation on veterans. The bill instructs them to conduct a small-scale study to review the findings of the 2018 RDA and determine if there are discrepancies with the DoD's findings. Then they will be required to report back to this committee so we can review their findings and determine next steps. The Secretary of the VA is also required to provide his plans to carry out any actions based on the study within 90 days of receiving the study. This bill will clean up some of the confusion around the DoD's RDA and address the concern of the cleanup veterans. This is the least we can do to ensure that those who served our country are getting the care and attention that they deserve, especially if their health was negatively impacted by the terms of their service. I urge you to support this bill and give these veterans the consideration they deserve. I ask that we report the bill favorably out of the committee to be considered by the full House. Thank you for your time.
Thank you. I thank the members who testified in support of these bills on the agenda today, and I would now like to invite those participating in panel number 2 to the witness table. Thank you. Okay, thank you. I would like to welcome Mr. Sullivan and his colleagues. It has been mentioned earlier, but I want to remind members that Mr. Sullivan and the others accompanying him, unfortunately, will not be answering questions on H.R. 299, the Blue Water Vietnam Veterans Act of 2019. This was a decision by the VA This subcommittee will hold a hearing on how the VA plans to implement the act at a later date, and we expect to have the VA to appear at that time. Welcome, Mr. Sullivan, and I would like to recognize you for your statement for 5 minutes.
Thank you. Madam Chair and members of the subcommittee, I am pleased to be here today to provide the views of the Department of Veterans Affairs on pending legislation affecting VA's programs. Accompanying me today is Kevin Friel, Deputy Director for Pension and Fiduciary from the Veterans Benefits Administration, Dr. Patricia Hastings, Deputy Chief Consultant, Post-Deployment Health Services from the Veterans Health Administration, and Derek Curtis, Director of Software Testing and 508 from the Enterprise Portfolio Management Division, Office of Information Technology. First, regarding H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2019, I would like to note that because the administration is still considering its legal options relative to the Procopio case, VA does not have any views to offer on this legislation, and we must respectfully decline to answer any questions you may have today regarding the bill. However, I will provide a brief summary of VA's views on the remaining legislation that is on the agenda today. As a representative of the National Cemetery Administration, I am pleased to note that 2 bills on the agenda, H.R. 1126, the Honoring Veterans Families Act, and the draft bill, now H.R. 2385, on establishing a grant program for the Veterans Legacy Program, are consistent with NCA-related proposals in the President's budget for FY 2020, and as such, VA supports both measures. The provisions of H.R. 1126 would be effective for veterans that die on or after October 1st, 2018, and we would ask that the subcommittee consider making this an earlier date by allowing VA to replace veterans' headstones or markers provided within the last 5 years to add information about recently deceased spouses and dependent children. As a leader in customer service, NCA is sensitive to the concerns of families when a benefit is added or changed, and suddenly what was not available for someone who died last year is available for someone who dies this year. H.R. 1199, the VA Website Accessibility Act of 2019, would direct VA to examine all departmental websites to determine whether the websites are accessible to individuals with disabilities in accordance with Section 508 of the Rehabilitation Act of 1973. The review would be conducted within 180 days of enactment, with the report submitted to Congress within 90 days of completing this study. While VA agrees with the intent of this legislation, we believe the bill is not necessary because it provides no new authority and because VA already has processes in place to review VA websites for noncompliance and remediate any identified issues. Moreover, we believe that attempting to conduct a universal review within 180 days would be logistically challenging. Lastly, we would advise that the inclusion of self-service kiosks within the department as part of this compliance review would be problematic, and we are willing to discuss our concerns with the subcommittee. H.R. 1200, the Veterans Compensation Cost of Living Adjustment Act of 2019, would increase the rates of disability compensation for service-connected veterans and the rates of dependency and indemnity compensation for survivors of veterans effective December 1st, 2019. The increase would mirror the Social Security benefit increase, also effective December 1st, 2019. VA strongly supports this bill because it would ensure that the value of these benefits keeps pace with increases in consumer prices. H.R. 1628, the Eniwetok Atoll Cleanup Radiation Study Act, would direct VA to enter into an agreement with the National Academies of Sciences, Engineering, and Medicine to conduct a study on radiation exposure related to the cleanup of Eniwetok Atoll. Subject to provision of funds to conduct the study, VA supports this legislation, which may answer the concerns of veterans who participated in the cleanup at Eniwetok Atoll. H.R. 1826, the Veterans Vow Act, would increase the Medal of Honor, or MOH, special pension rate and provide payment of MOH special pension to surviving spouses of a surviving spouse of a deceased MOH recipient. VA supports this bill, provided Congress can identify corresponding funding. Extending the MOH special pension to surviving spouses accords with other survivor benefits VA offers. However, VA would require clarification as to whether the remarriage limitations associated with DIC entitlement would apply to surviving spouses receiving the Medal of Honor Special Pension. For example, a surviving spouse who remarries prior to age 57 loses entitlement to DIC, but it is unclear whether a surviving spouse receiving the MOH special pension under this bill would also lose entitlement if they remarried. This concludes my statement, Madam Chair. We'd be happy now to consider any questions you or the other members of the subcommittee may have. Thank you.
Thank you, Mr. Sullivan. We will now begin with questions, and I will recognize myself for 5 minutes. I'd like to start with the VA Website Accessibility Act of 2019. You testified that a VA's Section 508 office currently scans the VA websites to identify non-compliant websites, files, and web-based applications. Is this true?
Madam Chair, I believe that is true, but I'm going to defer to my colleague, Mr. Curtis, who is the subject matter expert on that area.
Yes, ma'am. Thank you for the question. That is true.
So if it's true that you scan the websites, why is it difficult for you to provide a list to us of those that are compliant and those are non-compliant?
The scans take place every month. We contact the content owners to provide them that information so they can take the remediation actions. But I was unaware that there was a request for those results to be provided to this body.
Okay, as a result of this hearing, we would like information on which sites that are currently maintained by the VA are compliant and those that are not, so we can have an understanding of the scope of the problem of how many sites are not currently compliant. And I'm also going to quote from your testimony that there's no consolidated enterprise-wide plan to bring each website, file, or web-based application into compliance with the Section 508 of the Rehabilitation Act of 1973. Why is that?
Yes, ma'am. We work with the content owners, and there's differing complexities, and so our approach is to train them and equip them on how to build in the accessibility and let them go at the speed that they choose. Many of them are going faster than others, and so we didn't see a need for an enterprise-wide solution. And in fact, in the last 6 months, we've seen a marked increase in the number of websites that are becoming accessible.
Okay, so you can't tell me how many are or not accessible. You have no timeline for when you're requiring people to implement the changes. And then furthermore, you say that 180 days is not long enough for the VA to conduct a review. That was from Mr. Sullivan's testimony to determine whether its veterans-facing information sites are accessible. And then the report to Congress is not due for another 90 days after that. Can you explain the difficulty with the timeline? Why is 6 months not enough for you to determine the scope of the problem?
Part of the challenge is that kiosks were included into that definition of a website, and the standards are quite different for kiosks than they are for websites. Websites we scan remotely, and kiosks you physically have to go to each site and apply those different standards to check for accessibility, and that logistically would mean going to each and every facility and checking each and every kiosk within that facility.
But is there not a uniform host of software that's loaded on each kiosk that you would expect to find around at different VAs?
Similar, but not exactly the same. There is also a question of physical limitations associated with kiosks. Under the 508 standards, there are some physical parameters that have to be checked with your presence being there.
Okay, this is a very important issue, and I know that we'll hear from someone later on who personally, has experience with trying to access her benefits through these websites that are not accessible. So it's very important to me, so I'd like to continue this dialogue. If there are nuances within the way this is written that can help you do your job to get these benefits to veterans where they can access these websites, I'd like to, have more clarity on those specifics if we need to be, more specific in the legislation to accomplish the goal that we want to accomplish.
Yes, ma'am.
The second thing is, I'm very glad to hear, Mr. Sullivan, that the VA has no objections to the COLA bill introduced by myself and Ranking Member Bost. Do you foresee that there will be any problems implementing the cost of living increase on time?
Madam Chair, thank you for the question. I'm going to defer that question to Mr. Friel, who's a subject matter expert on that.
Yes, ma'am. Thank you for the question. As far as implementing it on time, we wouldn't predict any or foresee any problems with doing that, as we do it annually anyway, but we have to wait for Congress to determine what that rate will be. This will allow us actually to be more proactive, and it'll also provide a better opportunity for our beneficiaries, both veterans and survivors, to determine what they could see in their following year's benefit.
Thank you. And my last question is relative to the Veterans Legacy Program, HR 2385, introduced by Mr. Lamb. Do you anticipate any problems transitioning from the contract-based system to a grant-based system as proposed by this legislation?
Madam Chair, we do not expect any problems converting to that mode of dispersing funds. We think it will be a great improvement, another tool that we can access to more efficiently disperse those funds and partner with our universities and colleges to develop those educational materials.
Thank you. And do you anticipate any need for an increase in appropriated funds as a result to the changeover to the new system in this bill?
Madam Chair, we do not expect any additional appropriations will be necessary to start using the grant authority. We expect to be able to use our current appropriations and just use the method, the new method and the authority available to more efficiently use those funds.
Thank you. And I will now recognize Ranking Member Vost for 5 minutes for his questions.
Thank you, Chair. Mr. Sullivan, can you, and I know the answer, but I want it on record, can you please explain why it's important that Congress to reenact a cost of living adjustment compensation benefit every year?
Thank you for the question, Ranking Member. I'm going to refer to that question to Mr. Friel, who's the subject matter expert.
Yes, sir. Thank you for the question. The idea is, with the Congress giving us the cost of living adjustment, is there is nothing said in statute that says we can mandate us doing it automatically. So we have to wait for Congress to tell us what that rate will be. And then it's also a means of keeping veterans and their survivors, their benefits as a standard of living and to help them maintain that standard of living.
Mr. Sullivan, my next question I'm going to go ahead and ask, and you're probably not going to answer, but I'm going to ask it anyway, okay? The committee inferred that the Secretary, we're going to infer that the Secretary supports H.R. 299, given the recommendations not to appeal the federal court's decision.
Yes, Congressman. It is true that the Secretary has recommended not to appeal the decision to the Department of Justice, but the administration, the Solicitor General of the United States, and the Department of Justice have that final decision on whether to appeal or not, and we have to wait for that decision until we can provide official views or any of our official positions on that bill.
Okay, I appreciate that answer. Mr. Sullivan, I also want to ask how often, just for one of the bills here, is the NCA contacted about families' desire to add a memorial inscription for a spouse or dependent on a VA headstone that is not, or that is at a private cemetery?
Yes, Congressman. In the past fiscal year, we received approximately 900 requests for replacement headstone or marker that is currently placed at a private cemetery to add the spousal or eligible dependent inscription. That's actually a drop from our previous historical annual averages, which have been around 1,500 requests per year. And we believe that's due to the National Cemetery Administration being very proactive in the last fiscal year in terms of discussing with our funeral directors about the policy that we have to comply with, and they in turn discussing that with the family members.
Okay. I'm going to go in the same direction here on a question regarding that particular bill. In your, if you could elaborate a little bit on your testimony on H.R. 1126 regarding replacing headstone or marker is the most effective way to provide the spouse's dependent's inscription rather than just having it placed on. Can you explain how that's more cost effective?
Yes, sir. Thanks for the question. We issue headstones and markers for veterans that are placed in private cemeteries around the world. So it would be infeasible for us to go and amend those headstones and markers with spousal inscriptions. It would be much more cost effective for us to issue replacement markers that have the spouses or the eligible dependents' inscription information. Moreover, because a significant majority of the replacement headstones or markers that we issue for placement in a private cemetery are the bronze flat markers, Those are impossible to actually amend after issuance, so we have to provide a replacement headstone or marker for those.
Okay. Okay, I got the next question I have, look at my time here, but can you please give the details on the procedures that VA uses in relation to a compensation claim to verify a veteran's potential in-service exposure to harmful levels of radiation?
Because Mr. Friel is the subject matter expert for that, I'm going to defer this question to him.
Thank you.
Congressman, I'm going to have to take that for the record. My area of expertise is pensionary and fiduciary service. We typically do not deal with radiation exposure as it relates to our benefits, so we'd have to take that for the record.
Then for the record also, take the other part of it too, because the question was performing individual radiation dose assessment. Does the VA perform individual radiation dose assessments for veterans whose service record indicate that they may have been exposed to high levels of radiation? And if you can get that back, that'll be fine. So.
We will take both of those back for the record, sir, but Dr. Patricia Hastings from VHA is here, and she can provide some insight to the second part of that question.
Sir, if a person believes that their illness has been caused by radiation incurred during military service, they are able to put in a claim. At the time the claim goes in, if it is not a presumptive disease, it would go to VBA. They would request a comp and pen exam, which would then go back to the VBA. At that time, they would send it to my office for an advisory medical opinion, and that is a health physicist that does a dose reconstruction based on actual dosages, or if we do not have dosages, the highest dosage which would be possible. We always give the benefit to the veteran. That then goes back to the regional office that does these. That's in Jackson, Mississippi, where they have the experts that work on the radiation claims. At that point in time, it is adjudicated, a decision is made. If the veteran disagrees with the opinion, they are able to appeal. If they disagree with that, they can go to the Veterans Benefits, or the BVA, the Board of Veteran Appeals, and if they disagree with that, they can go to the Court of Appeals for veteran claims.
So the normal procedure.
It is a normal procedure with the caveat we do an advisory medical opinion, a health physicist, and I see all of those.
Okay, thank you, and I yield back.
Thank you, Ranking Member Bost. With unanimous consent, I would like to recognize Representative Brownlee, who is here to speak on behalf of Mr. Lamb's bill.
Thank you, Madam Chair, and thank you for the opportunity to attend your meeting and speak at this hearing. I'm here today to discuss the Veterans Vow Act, H.R. 1826, introduced by Representative Lamb, and similar legislation that I have separately introduced. We all know the great sacrifices that families of service members make, especially those who lose loved ones. When living service members are awarded the Medal of Honor, they receive a special pension in recognition of their heroism. But when those Medal of Honor recipients are deceased, their loved ones receive no such compensation. Representative Lamb's bill honors the spouses of these heroes by ensuring that they receive the same pension that the deceased service member would have otherwise received. I've also introduced legislation, H.R. 1779, that would authorize Medal of Honor recipients to designate an individual to receive the special pension upon their death and establish a process for awarding the pension to a loved one if a Medal of Honor is awarded posthumously. I was inspired to introduce this legislation after having had the privilege of meeting a Gold Star mother, Dahlia Gonzalez, whose only son, Freddie, died in Vietnam and was awarded the Medal of Honor for his heroism. Freddie was in the same company as one of my constituents, Sergeant Major John Canley, who is also a Medal of Honor recipient. It was in coming together to acknowledge and pay tribute to Sergeant Major Canley's heroism that I met Miss Gonzalez. Now in her late 80s, Miss Gonzalez dropped out of school in the 7th grade to help her mother after her father's passing. She gave birth to Freddie when she was 16 and raised him as a single mother, working as a waitress and then at a grocery store to provide for her only child. Her devotion to her son ensured that he graduated from high school, after which he fulfilled a childhood dream of serving his nation by joining the Marine Corps. In 1968, Sergeant Gonzalez lost his life during his second tour in Vietnam, a tour he insisted on taking, fighting for his men and his nation. Ms. Gonzalez was at her job at the restaurant when she received the tragic news of his passing. As we now know, Sergeant Gonzalez was awarded the Medal of Honor for his heroism in Vietnam. Since then, Ms. Gonzalez has grown close to the Marines that served with her son, and they have helped her with travel to reunions and other financial needs. But still, I believe more can be done. Although her only child had given his life for our nation in battle, she has struggled to make ends meet in her later years, now that she is no longer able to work. Our country should do more to support surviving family members of service members who have received the highest award for valor our nation can bestow. I wholeheartedly support Vice Chairman Lamb's legislation that does just that. We absolutely owe this benefit to the spouses of our heroes. As I have gotten to know Ms. Gonzalez and the sacrifices she made for her son, I am compelled to ensure that parents and other family members also receive recognition and compensation. Providing a special pension is just one token to recognize the sacrifice that veterans have made on behalf of our nation and the sacrifice that their dependents have also had to bear. I am pleased that this subcommittee is considering this important issue, and I hope to work closely with my colleagues on legislation to allow parents and other loved ones, like Ms. Gonzalez, to receive this benefit. I thank you again, Chairwoman, for the opportunity to speak, and I would just like to say I love seeing you in the chair position, and I thank you for your service to our nation, and I know without a doubt you are going to do an extraordinary job on the VA committee and chairing this particular and very important committee, so thank you for your service as well. That service as well, and I yield back.
Well, thank you, and thank you for taking the time to come before our committee today to speak on behalf of that important legislation. I would next like to call on Chairman Takano for his comments and questions.
Thank you, Madam Chair, and I too do like seeing you in that position as well. Let me ask the VA, Mr. Sullivan, regarding the outreach program, the Veterans Legacy Program, and Bill H.R. 2385 by Mr. Lamb. Do you see any advantage in the idea of piloting this change before it's enacted?
I think piloting changes does provide some insight before full implementation, but I do also feel pretty confident that we can exercise any new grant authority pretty effectively. Within the National Cemetery Administration, we do already have a grants account that we execute for the State and Tribal Veteran Cemetery Grants Program. So we do have expertise and experience in that arena. So while a pilot would always provide you some early insight and ability to make some corrections, I think we have the expertise to immediately implement this authority once received.
Given that Professor Hedgecock has had some time and some experience with the Legacy Program, would you accept input from someone like her regarding the best practices for the Legacy Program?
Yes, Congressman, thank you for the question. I would definitely accept input from someone with that expertise, and I believe the professor has already been in some discussion with our program manager for the Veterans Legacy Program. So we welcome that input from the educational community.
So she's already been giving you some feedback on maybe how to improve the program going forward.
Yes, sir, we would definitely welcome that input and feedback.
Well, thank you, wonderful. I'd like to, Ms. Brunson, with the Blinded Veterans Association. I want to know about I appreciate the work you've done. Next panel. Okay. I'm sorry, I got confused there. Let's see, who else can we? This one here? Okay, great. All right, Mr. Sullivan, let me continue questioning with you. So I'm glad to hear that the VA has no objections to the COLA bill introduced by Chairwoman Luria and co-sponsored by Ranking Member Bost. Do you foresee there will be any problems implementing the cost of living increase on time?
I'm going to defer that question to Mr. Friel, who's the subject matter expert. Thank you.
Thank you, sir. No, as I said earlier, we do the COLA adjustments normally annually. Anyway, we have a process in place to actually implement that and make it happen. This bill would allow us to actually be more proactive. Instead of having to wait for the decision on what the COLA rate would be, this would give us, we could tie it directly to what Social Security does and be able to move forward.
All right. Well, thank you. I appreciate your answer. I yield back, Madam Chair.
Thank you. I now recognize Ranking Member Dr. Rowe for 5 minutes.
Thank you. Thank you, Madam Chair. First of all, Mr. Sullivan, I want to give a shout out to the National Cemetery Administration. You all do an outstanding job. I think anyone who visits our cemeteries can be very proud of them. So thank you for that job. And since January, my staff's asked at least 3 times for information on how VA plans to move forward the processing of the Blue Water Navy claims given the Procopio decision and subsequent mandate. The department's response has been that while the Solicitor General decides whether to appeal the decision, it would be premature for the VA to conduct a briefing on this topic. However, the holding in Procopio is the current law of the land. It is the law of the land now. The Supreme Court would have to grant a cert on appeal and overturn the Federal Circuit's decision for VA to have the authority not to implement the decision. This could take years, or it may not ever happen. So these veterans have waited long enough for a decision, and if VA has not already started enforcing Procopio, it is a violation of the law. Mr. Sullivan, what steps is VA taking to implement this decision?
Thank you for the question, Dr. Rowe. I understand that Secretary Wilkie has been proactive in making sure that the department has started to think about what steps would be necessary. However, because this decision on whether to appeal the Procopio decision is still pending, and I believe that the extension was granted to May 29th, we are unable to provide any details on how we may implement the Blue Water Navy decision at this time. I believe that once that decision on whether to appeal the Procopio decision is made, there will necessarily need to be detailed discussions within the department and with Congress to implement whatever next steps need to be implemented.
Let me share, and I know VA understands this, is that 523 of us are dying every day, Vietnam veterans. And I know I walked all over the DMZ in Korea, and not too distant from the time that Agent Orange was sprayed there myself. So I have some vested interest in this, and I see people and talk to them all the time. This appeal may never happen. And I know you're not a mind reader and you can't decide what the solicitor is going to do. But if I were you all and I were the secretary, I would encourage him the next couple of weeks to let this committee know, are you proceeding with this? Because if I were in his position, I would move forward and have somebody tell me to stop. That's what I would do. And the reason is we've got men and women, mainly men across this country, who've been waiting for almost 50 years for this decision. And so can I have your commitment in the next 2 weeks and from the VA will give us some direction? I know you said you had to wait until this next decision. That could, I mean, I've seen lawyers in 3-piece suits and Alan Edmund shoes run something out for decades so in the courts while we've got people dying. Could we do that?
Sir, again, we sympathize with the views of Blue Water Navy veterans. Most of us on this panel are veterans, and I know that from listening to the Secretary speak, he has veterans at his heart every day. And you know, we are working to be forward-leaning in case the Department of Justice decides not to appeal the Procopio decision. However, at this time, we just cannot provide a commitment. I do not want to presume to speak for the Secretary on whether we can provide these further details until that decision on whether to appeal or not has been made by the administration.
Madam Chair, I ask unanimous consent that these three documents be entered into the record. I know I'm pushing you pretty hard on this.
Without objection.
Thank you, Madam Chair. I know we're pushing you pretty hard, but it's time we got this resolved. I mean, I've been on this committee for 10 and a half years. I know the chairman worked very closely with me last year. We got this passed through the House unanimously, and there are veterans out there that I run into every single day when I go home that ask me about this. And I don't think that this committee or this country can tolerate any more delays since we've got a clear direction from the court now. And, you know, whether they appeal or not, they could delay that decision 6 months if they wanted to. So I would encourage the VA to put the pedal to the metal. With that, I yield back.
Thank you, Dr. Rowe. I now call on Representative Cisneros for 5 minutes.
Thank you, Madam Chair. Excuse me, Mr. Sullivan. Just a quick question about HR 1126. Is it possible when the veteran, they know it's a married couple and they know they want to be buried together, is it possible for them to get a marker or a headstone that already allows them to have both of their names on that headstone?
Thank you for the question, Congressman. That depends on the placement of where that burial headstone or marker is placed. So in our national cemeteries, in our grant-funded state and tribal veteran cemeteries, veterans and their eligible spouses and dependents are already eligible for a burial headstone or marker. So in many cases where the veteran is buried in the same gravesite as their spouse or eligible dependent, we already know that we're able to provide a burial headstone or marker or a replacement burial headstone or marker that includes both the information of the veteran and the information of the dependent or spouse. However, we do not have the authority to provide a separate burial headstone or marker for spouses or eligible dependents in a private cemetery.
Well, I'm not talking about a separate tombstone like my uncle and my aunt. When my uncle passed away, they got a tombstone that had already a spot for my uncle's, his name and his life information, and also for my aunt and her information. Is the VA able to do that?
With this new authority, if we receive this new authority, we would be able to provide either a burial headstone or marker with both the veteran's information and the spouse's information if the veteran, or if the spouse predeceases the veteran. So if the spouse predeceases the veteran at the time of the veteran's death, with this new authority, we would be able to provide a headstone or marker with both the veteran's information and the spouse's information. However, if the veteran predeceases the spouse, the veteran would be issued a headstone or marker with the veteran information, and that would be placed in the private cemetery. And then only upon the death of the spouse or eligible dependent would we be able to issue a replacement headstone or marker that includes both the veteran's information and the spouse's or dependent's information. And the reason we have to do that is because we only have authority to mark that grave with the spouse's information with this new authority upon the death of that spouse. So we would not be able to mark that grave with the spouse's information prior to those remains being in that gravesite.
And then on HR 2385, I just want to make a comment about that. I think it's a great idea that the VA, the national cemeteries, are allowed to collect this information. The Navy Memorial, which is a nonprofit organization here, has a website that they call the Navy Log, and you can actually go to the Navy Memorial as well, which is located here in DC. But every acting or former service member, veteran of the sea service, whether it be a Navy, Coast Guard, Marine, or even the Merchant Marine, is allowed to kind of put their information into that log and keep track of it. So very supportive of 2385. I think it's a great way to collect this information, And so I just wanted to get that on the record, that I think it's a great idea, and we need to collect the information for our veterans so that we have a history of those individuals and the service that they did to this country. And with that, I yield back my time.
Thank you, Mr. Cisneros. I now call on Mr. Burlakis for 5 minutes.
Thank you. Thank you, Madam Chair. I appreciate it very much. And first of all, I want to associate my comments with Dr. Rowe. Our Blue Water Navy veterans have waited too long. And my question for the entire panel will start with Dr. Sullivan. Given the recent history, how do you believe the VA and DOD should work together and with Congress and stakeholders to address future toxic exposure issues to ensure that we have evidence-based scientific data necessary to determine whether a disability is linked to military service? Again, we've obviously, Agent Orange, our Vietnam veterans, have waited too long over the years, and now we have the toxic waste. We have what's going on in Iraq and Afghanistan, the burn pit issue. And we've got to get this right, and our heroes waiting too long, and we have to work together because it's just not fair. So, Dr. Sullivan, please, if you can answer that question, I would appreciate it. And if the panel has any input, please give it to us.
Thank you for the question, sir. Undoubtedly, VA needs to work with DOD and Congress to address these veterans' needs. I think the person on this panel that could best speak to that would be Dr. Hastings, so I'm going to refer this question to her.
Okay, that's fine. Please.
Thank you, Mr. Sullivan. Sir, we work with DOD very closely in post-deployment health services at the VA. We have a deployment health working group that meets monthly. We have other groups that work on issues. Congress has been very helpful to us with the Airborne Hazards Open Burn Pit Registry, which is very active, and we are starting to data mine that. We also have worked very closely with your help with the National Academy of Science, Engineering, and Medicine to answer some of the questions that are important to veterans. One thing that we are doing that is very exciting is the individual longitudinal exposure record. In my office right now, we have 6 registries. We have the Agent Orange Registry, the Gulf War Registry, the Toxic Embedded Fragment Registry, the DU Registry, Depleted Uranium, Airborne Hazards. So these are separate registries, but if we're working with DOD on the individual longitudinal exposure record, which would be a record that starts the day that the person signs into basic. It would include all of their deployments, where they've been, any monitoring that's done in the area, and we would be proactively looking at exposures. We would be able to build cohorts. For example, if we found out there was a problem later on, as we did at Karmat Ali, the water treatment plant in Iraq, that there was chromium there, and we're following those veterans right now. There are about 700 of them. We would be able to say, there's been a problem here, we need to look at these people specifically. We would be able to get a hold of people better. We would be able to build cohorts for research. But the individual longitudinal exposure record is extremely powerful. It goes into its initial operating phase this fall, and it's been with your help that we've been able to do that.
Thank you. But I want to make a statement. How about giving them the benefit of the doubt and giving them health care immediately, the VA? All right, I'll go on to the next question for Mr. Sullivan. Mr. Sullivan, what criteria does the department use to award contracts for the Veterans Legacy Program?
Yes, Congressman. We have several criteria for the legacy contracts. First, only universities or nonprofit education organizations may apply. The teams that are working on developing the Veterans Legacy Program material must be led by tenure-track faculty with terminal degrees. Undergraduates and graduates that are engaged in veterans research must be researching in an instructional context, or in other words, it must be part of coursework. Faculty teams must partner with local K-12 teachers who will engage their students. Students will research veterans interred in national cemeteries of focus near the near the universities or colleges that are working on developing these products. Students must visit the National Cemetery of Focus. Students that are conducting research must produce research in a form that will be accessible to the public. Faculty teams must work with their K-12 partners to produce instructional materials that are standards aligned, and they must develop at least 5 lesson plans for use in K-12 education and define plans to extend the memorialization of veterans' legacy. The project plans must include designs for instruments to assess the effectiveness of student participation in the program, and the students must participate in either Memorial Day or Veterans Day ceremonies at the National Cemeteries of Focus.
All right, thank you very much. Appreciate it. Thank you for your testimony. I yield back, Madam Chair. Thank you.
Thank you, and I think that concludes questions from the members of the subcommittee. So thank you, Mr. Sullivan, Mr. Friel, Mr. Curtis, and Dr. Hastings for appearing for us today. I would like to invite the third panel of witnesses to the table. As they come forward, I will introduce the witnesses on the third panel. We have Ms. Melanie Brunson, Government Relations Officer for the Blinded Veterans Association, Mr. Carl R. Horst, retired U.S. Army Major General and President and CEO of the Congressional Medal of Honor Foundation, also joined by Ms. Allison Hedge Koch, Distinguished Professor of Creative Writing at the University of California, Riverside. So, Ms. Brunson, I would like to recognize you first for 5 minutes for your statement.
My apologies. Thank you, Chairwoman Luria, Ranking Member Bost, and distinguished members of this subcommittee for the opportunity to speak to you today. As the only veteran service organization exclusively dedicated to meeting the needs of blinded veterans and their families, BVA is pleased to support the legislation that is under consideration by this subcommittee today. We believe that these bills will positively impact the quality of life for veterans and their families. I will focus the remainder of my remarks on one of these bills in particular, H.R. 1199, the VA Website Accessibility Act. BVA supported this legislation when it was first introduced in the last Congress, and we were very pleased when it passed the House with bipartisan support. We hope the current House will repeat this result and that this time the Senate will also pass this legislation. BVA supported this legislation and continues to do so. Although the situation has improved in recent years, the fact remains that VA regularly releases web pages and other forms of communication that pose major accessibility barriers for some of our nation's most vulnerable veterans, those with catastrophic disabilities such as blindness and traumatic brain injuries that impair their ability to read. There's an expectation today that virtually every communication between government and the people it serves can be conducted online and by the use of smart devices. This expectation is shared by many veterans, including some with disabilities. Veterans have come to expect the ability to do things like schedule appointments at VA medical centers, fill prescriptions, and file claims for VA benefits online at any time, day or night. Increasingly, both the VA and the veterans it serves find devices helpful. Kiosks help with check-in for appointments at medical centers, and video conferencing technology enables consultation between doctors and patients that might not otherwise occur. Under these circumstances, any time that issues related to the accessibility of such tools for veterans with disabilities are minimized or overlooked, some of our nation's most vulnerable veterans are left behind. Then, when these veterans can't access VA programs or services, this can in turn lead to more serious consequences, such as exacerbation of their disabilities, depression, and possibly suicide. The longer VA waits to address such accessibility barriers, the greater the risk to these veterans. BVA believes this waiting game should end now, and the person who can most effectively put an end to it is VA Secretary Robert Wilkie. Unless and until VA's leaders make it known that they are committed to ensuring that VA's electronic communications are accessible to all veterans, including those with disabilities, the wait will continue and some veterans will be left out to their detriment. H.R. 1199 provides an impetus for such a commitment by VA's leadership. But this legislation will only do so much. Its requirement that the VA Secretary file a report to Congress containing a plan for addressing current accessibility barriers, though beneficial, does not ensure the subsequent removal of those barriers, nor does it ensure that those barriers or others won't reappear in the future. We therefore urge the members of this committee to support this legislation as the means of beginning a long-term effort by Congress to use its oversight authority to ensure that VA communicates using media that are accessible to all veterans regardless of disability. If Congress gets serious about accessibility, VA's leadership will have yet another reason to do so. With that, I will conclude by saying thank you again for this opportunity, and I'm happy to answer any questions you may have.
Ms. Brunson, thank you again for being here today and for your remarks. I will now recognize General Horst for 5 minutes.
Madam Chair, thank you for your service and thank you for your leadership of this subcommittee, as well as the distinguished support of your committee for our veterans. It's an honor and a privilege for me to be here this afternoon. At the Congressional Medal of Honor Foundation, we have the privilege of working with our nation's truest heroes, the recipients of the Medal of Honor. The mission of the Medal of Honor Foundation is to support the Medal of Honor Society, the recipients and their outreach programs, and to preserve the legacy of the Medal of Honor through education, outreach, and recognition. The foundation also preserves the legacy of the Medal of Honor by promoting American values, specifically the qualities of courage, sacrifice, selflessness, patriotism, citizenship, and integrity. I'm here today to reinforce and advocate for the Congressional Medal of Honor Society's position supporting H.R. 1826, the Veterans Valuing Our Widows and Widowers Act. The Society concurs with the language in the legislation outlining the payment of a special pension to the surviving spouses of Medal of Honor recipients. In the absence of a surviving spouse, the Society believes the special pension should follow a succession to the designated next of kin caregivers to receive the special pension from the federal government. The committee's initiative to amend H.R. 1826 is both timely and necessary. Today, there are only 71 living recipients of the Medal of Honor, and they're a rapidly diminishing national treasure. Since January 15th this year, 3 more recipients have passed. The average age of the living recipient is 73 years old. The average age of the 58 World War II, Korea, and Vietnam veterans is 79 years of age. In fact, 18 of our living recipients are more than 80 years old. We at the Foundation have an opportunity to work with the Medal of Honor recipients at events throughout the year. I have seen firsthand how important spouses and caregivers are to our Medal of Honor recipients. In most cases, the caregivers are next of kin family members. There are some instances where caregivers are not next of kin. However, to be clear, the Medal of Honor Society only supports the designated next of kin caregivers to be eligible to receive the special pension. The spouses and caregivers work tirelessly to ensure the recipients are able to participate in outreach events where they interact with the American public. In fact, spouses and caregivers allow recipients to travel and participate in outreach programs far beyond the normal age where most Americans will retire or limit their travel. The recipient stories of courage and valor in combat and their compassion for fellow Americans are inspiring to all who have the opportunity to come in contact with them. Their spouses and next of kin caregivers help make that possible, and this legislation is appropriate to support them and the recipients. The Society feels that the special pension is so important that the Society provides a one-year continuation of this compensation to ease the burden on surviving spouses and designated next of caregivers. Madam Chair, thank you for the opportunity to be here today, and I'm happy to take questions at your direction.
Thank you, General Horst. I now call on Professor Hedge Cook. You are recognized for 5 minutes for your statement.
Subcommittee Chair Luria, Ranking Member Bosk, and members of the subcommittee, I want to thank you for the opportunity to testify before you today. My name is Allison Hedgecoke. I'm here on behalf of the University of California at Riverside in support of the draft bill to permit the Secretary of Veterans Affairs to establish a grant program to conduct cemetery research and to produce educational materials for the Veterans Legacy Program. I'm a poet, writer, and distinguished professor of creative writing within the College of Humanities, Arts, and Social Sciences, and the principal investigator of Along the Chaparral, Memorializing the Enshrined, a cemetery research story project. Story and culture are inextricable and are the common thread of human knowledge. You might imagine story as a continually evolving multidimensional entity, spherical, that we intersect with on an as-need-to-know basis to learn in human society. The site we work with, Riverside National Cemetery, represents story of life in our region. It represents honor and service, an ulterior hope for peace. It represents the greater remarkable lives that continually add to the story, whereas the surrounding populations have at stake value from kinships that are interred here. Bringing UCR students and recent alumni into classrooms to foster story and research programming encourages K-12 students to look to education. Classroom youth have significant ties to the cemetery. They may not realize until the project is on their desk and they've given themselves to the discovery of family and neighborhood ties. Story creates culture. It teaches us who we are and how to be in the world, and it leads our futures. The Legacy Program delivers this terrific meeting of story and culture and bridges the university to K-12 schools and surrounding cultures and communities that make up our region. In tribute to those interred, we created an interactive GIS web story app and mapped the cemetery with cutting-edge digital mapping. Its populated points affiliate hundreds of resulting K-12 tribute stories to subject gravestones. We published a print anthology. We've produced 2 documentary film archives, including 9 films, a making-of documentary and 8 portrait vignettes of those interred. We've produced 5 K-12 student performances, an internationally broadcast radio play of stories. We've also produced dozens of lesson plans toward a curriculum base in 14 months. To date, we've worked successfully and collaboratively with over 2,700 K-12 students in approximately 100 classrooms in these 14 months, in public schools and at Sherman Indian School, whereas an ongoing project has started for a veterans mural at Sherman Indian High School. 2, the project has fostered an understanding for our research library, the Tomas Rivera Library, to serve as a receptacle for memorabilia donated to the Riverside National Cemetery by next of kin. Challenges within the contract versus grant include the university system, formulated to address a more typical faculty grant system, whereas calls for proposals give a generous length of response, and proposal calls and submissions coincide with our academic programming. The initial legacy program call came during winter holiday, whereas to step up as a PI, I was left to create the contract without regular support of primary contacts within the university and without the ability to continue planning with K-12 schools who were also on holiday. The second call came in the holiday week in November, so to write the proposals, my major holidays in 2017 and 18 were both sacrificed. If the university has a grant opposed to contract, the system is set up as a drawdown, so at the end of each month, the university can draw down electronic funds to pay as services rendered. The grant would allow for more regular and fluid payments in this case, and service paid as served, and greater ease of ability of institutional service to the program. A grant program would solve these dilemmas and ease our collaborative work. I want to thank you for allowing me to be here. I know that many of you are strong supporters and advocates for veterans. I also want to leave on the record our thanks to our representative, Chairman Takano, for recent visits and for allowing us to speak with Randy Reeves, the Undersecretary, about our project recently, and for serving our Native vets as well on campus. I'll be delighted to answer any questions you may have.
Thank you, Professor Hedgecote. I now recognize myself for 5 minutes for questions, and I'd like to start with Ms. Brunson. I greatly appreciate the work that you have done to advocate for and improve access for visually impaired veterans. I was concerned to hear that access to the Veterans Crisis Line, the chat feature, was temporarily lost for visually impaired veterans last year. Do you feel that implementation of HR 1199 would help reduce loss to access to these critical services in the future?
To the extent that this legislation does put in place the mechanism for developing a plan to access those features, to resolve those access barriers that exist at the time that the evaluation and report are done, yes, indeed. This is a welcome process. The plan for action would be a good thing because, as the VA witness noted earlier, there isn't currently an enterprise-wide plan in place, and we believe that there needs to be a greater focus within the VA on resolving such barriers. And the way to do that is to focus more attention across all the business lines.
Thank you. And can you explain to us some of the technologies that are most useful and most impactful for the blind as far as accessing websites?
Many blinded veterans currently use smartphones because both Android phones and the iPhones in particular have screen readers that are built into them. And by turning on magnification features or features that make the phones talk, one can go online freely using the web browsers that are built in. Of course, blind veterans in particular, and those with other reading disabilities as well, have been using computers to access websites for a long time. Even devices like kiosks are equipped commonly with accessibility features.
So you would assess that these are readily available technologies
correct.
that many people who are blind or visually impaired are already familiar with, and they're not particularly costly or difficult to implement because they're widely used elsewhere.
That's correct.
Thank you. I will now turn to General Horst. Thank you for being here as well. And one of the responsibilities of the DAMA subcommittee is to appropriately memorialize veterans, and your foundation does an amazing job of preserving this legacy of service and so often the great sacrifice of our heroes. You suggest an amendment that would allow honorees to designate next of kin caregivers as eligible to receive the special pension. Would you envision this designation to be for the lifetime of that designee?
Thank you for that question, ma'am. No, we would envision it to be for the same one-year period that is for the spouse. For the surviving spouse, we would make the same recommendation for a next of kin caregiver, that it would be a one-year period.
Just for clarification, I guess I misunderstood. I thought that the way the bill was written was that it would be a continuing benefit. Okay.
If you see it as a continuing benefit, then we would support that continuing benefit for a next of kin caregiver, as designated by the Medal of Honor recipient.
And how does the foundation view the suggestion by some that the designation for the surviving spouse should end in the event of remarriage, for example, at the age of 55, such as in other programs?
We believe that the criteria for the surviving spouse or next of kin caregiver would be consistent with the DIC criteria. It should mirror the VA's criteria as well. So at age 57, before age 57, if a next of kin or a surviving spouse remarries, then they would lose that benefit. The special pension should mirror DIC.
Thank you. And I yield back the remainder of my time, and I now call on Ranking Member Bost for his questions.
Thank you, and Chair, and Ms. Brunson, I know you've already expanded, and my question was almost similar to the chair's, but I would like to know an explanation for whenever such as an e-benefit right now, if you go online, if you are with your organization are blind, you can't access it now. Is that correct?
There's a lot of variation between what is accessible and what isn't. Some of the websites and some of the online tools work wonderfully, others do not. It is sometimes simple as things like you can, on occasion, fill out a form, get all the information loaded, but you can't find the submit button. There are sometimes features that prevent one from completing a task that you can partially do. But there are other times when there are varying degrees, I guess, of accessibility based or depending on which resource you're talking about.
Has your organization worked already with the VA to notify them on which areas we would want to, which ones are working and which ones aren't?
Yes, we meet regularly with the staff of the Section 508 office, and we point out to them anytime we encounter or our members notify us about issues, and they try to be very responsive in resolving them, but sometimes it does take us to let them know.
Okay. All right, well, hopefully we'll pass this legislation and we'll be able to make sure that how important that is. I think all of us can agree. Next question is for Ms. Hedgecock. If you could you expand again, because I heard it in your testimony, how difficult it is, or what the different problems that exist with the difference between a grant and what the contract is at this time?
Okay, so financially for the university, grants are on what's called a drawdown system, and contracts are paid at the end of. So on a drawdown system, monthly funds become available to pay out for services rendered. And with the contract, the funds are released at the end for the most part. So the university is without supporting funds and is taking it out of their own care to cover the program. So it's not something universities are used to doing. The system is really set up for a grant system. Two, within this, I was mentioning faculty issues. The VA had come to our campus several times to talk about opportunity with Legacy program when they were initiating interests at universities nationwide. I was in Montenegro doing some things for the embassy the first time they came. I was out of state another time. And I got back. They couldn't get anyone to step up as PI. And I said I would love to do it. My father's a World War II vet. He had recently passed away. He got through World War II reading Rumi. And I came into poetry as a poet, reading Randall Jarrell's Ball Turret Gunner. These things are effective in my work as a writer. I work in film. All the assets of the program that are used in our project, I have done and knew I could lead. So I stepped up as PI. I had no university primary consultations available to me because people were on to winter break. The K-12 schools I intended to work with were also on winter break. So it's one thing when I sacrifice my winter holiday, it's another thing when the resources that are normally available to a faculty member are not. So I don't know that anyone else would have stepped up. And the same thing happened in the next contract period for the next 2 years. It came on a Thanksgiving, so another holiday sacrifice with minimal support. Yeah.
Thank you. I yield back.
Thank you. I now call on Chairman Takano.
Thank you. Welcome, Professor Hedgecock. It's good to see you here. Can you tell the committee how much support our community has, the Inland Empire and Riverside, for this legacy program?
I'd be happy to. It's a great pleasure. The region that we are in, Riverside National Cemetery, serves a 70-mile parameter. Within this region, depending on who you're talking to or what year they're looking at, rationales to decide the numbers, it's anywhere between 4th and 8th in the nation for service in different aspects, which is a huge contingency of service over the years. There are also 19 reservations in the local area, 4 which have proximity to the cemetery site. As you know, Native vets have always had a high military service as well. The Latino community there has been a call group during times of action for frontline members and service. So we have a very large network of veteran families. As I said a minute ago, the kids are connected inextricably from this site. When our project lands in their classroom, oftentimes a third of the room has somebody that they came from, they descended from, buried there. So we may assign them a name and they'll raise their hand and say, well, my grandma says I have to do Uncle Bob. And that happens quite often. So we're helping to reinvigorate the community's involvement with those that have passed as well, and keeping their stories memorialized and live. King High School has a program in Riverside which does oratory from living vets every year. It's a 10-year program. When I started this project and went to King High, the first roster we used was their final roll count that they had done over the years of people that they had interviewed. And I located who was buried at this cemetery, and that was our start group that we isolated for story. We have about 200 student veterans on our campus. The veteran population on campus is somewhere around 450, including dependents of active and veteran military service members. We have a veterans center on campus. I also teach in the medical school in narrative medicine, and my students serve, who are humanities students, serve the vet center during finals and coping techniques and such through story. My medical students have hospitals to do this in. But we have a huge contingency of service active people and former service members, many disabled citizens. We're very near March Air Force Field, brought a lot of people to that area of California as well. I think that's the nutshell.
Well, Professor Hedgecock, I mean, you also mentioned the Native American tribes.
Yes.
Has there been much interest among the tribal members?
Oh, yes, and I have to say of our team on campus, a large contingency of the co-PIs and myself are affiliated with the California Center for Native Nations on campus, and we were the first to step up on campus. Many of the students involved are also Native and/or work in Native studies. And in the school districts, serving in classrooms, a lot of the students who are going out to serve the kids also from that background. In addition to Sherman Indian School, we're adding in Anza and Noli this summer. And not only did Sherman work at doing storying, but they put together the radio play that we broadcast internationally last November. And they created the mural that's now up at cafeteria area, Veterans Mural. They also have a lot of veterans powwows, not only on the reservations, but in the urban communities and at Native School as well.
Wow, that's, and of course, the prominent Latino veteran, Ishmael Villegas,
Yes.
is a Congressional Medal of Honor recipient.
Absolutely.
So we have a cast wide net in terms of the story that we tell. The stories that we tell really are quite diverse and inspiring of the history that they bring.
Yes, also Tuskegee Airmen are out there. There's a lot of women soldiers buried out there, Asian American soldiers. It's not a microcosm of society. It's the same size as Riverside, so it's Twin Cities, the living and the dead. So it's a separate macrocosm of society there.
Well, thank you. I yield back, Madam Chair.
Thank you, Chairman Takano. I now call on Ranking Member Rowe. No questions. Well, thank you very much to our panel for appearing today and taking time to provide your statements and answer questions. I would now like to call the fourth panel to the witness table. So as they come to the table, I'll introduce the members of the fourth panel. This includes Mr. Carlos Fuentes, Director of the National Legislative Service for the Veterans of Foreign Wars, Mr. Rick Weidman, Executive Director, Policy and Government Affairs at the Vietnam Veterans of America, Mr. Shannon Nudavong, Veterans Affairs and Rehabilitation Division Director at the American Legion, Mr. Shane Learman, Assistant National Legislative Director at the Disabled American Veterans, and Mr. David Butler, Director of the Office of Military and Veteran Health at the National Academies of Science, Engineering, and Medicine. I'd like to thank you all for being here today. We'll start with Mr. Fuentes. Mr. Fuentes, you're recognized for 5 minutes.
Chairwoman Laria, Ranking Member Boston, members of the subcommittee, on behalf of the VFW and our auxiliary, thank you for the opportunity to present our views on legislation pending for the committee. I'd like to first begin by thanking the committee, the chairman, the ranking member, and especially the staff for your tireless dedication and hard work on HR 299, and for working to ensure the Blue Water Navy veterans receive the benefits they have been wrongfully denied for more than a decade. The VFW was rejoiced when the overwhelming decision of the VFW-supported Procopio versus Wilkie court case, which reversed a years-long ruling and paved the way for the restoration of benefits for Blue Water Navy veterans. We'd also like to thank Secretary Wilkie for his recommendation to not appeal the decision. However, the decision can be challenged and overturned in the future. Congress must pass H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2019, to make certain that Blue Water Navy veterans never have their benefits taken away ever again. This bill also includes expansion of much-needed benefits for Korea DMZ veterans and Thailand veterans. The VFW supports expansion of benefits for Korea DMZ veterans who suffer from diseases and illnesses directly linked to Agent Orange exposure. While many of these veterans receive presumptive disability compensation for their service-connected conditions, hundreds are left out despite clear congressional intention for them to be included. This legislation would provide them the benefits they have also been wrongfully denied. H.R. 299 unfortunately did not pass last Congress because one senator doesn't believe that Agent Orange made Blue Water Navy veterans sick, and another one was concerned with the cost. This Congress cannot let veterans down again. The VFW supports the Honoring Veterans Families Act, which would authorize VA to properly recognize the surviving spouse and dependents of our nation's veterans. The VFW is also glad this bill would establish a retroactive effective date to properly recognize a spouse and dependent who is already buried with an eligible veteran, but lacks the proper recognition on the veteran's headstone. The VFW would, however, recommend that the subcommittee align the effective date with a recently passed public law which would authorize VA to provide headstones for certain spouses and dependents who die on or after November 11, 1998. The VFW supports the Veterans Compensation Cost of Living Adjustment Act of 2019, which would increase VA compensation for veterans and survivors and other benefits. The VFW is pleased to support any bill increasing COLA for veterans. However, we would prefer the COLA be made permanent and an automatic increase. The VFW also supports the Inuit Atoll Cleanup Radiation Study Act. Those who wear the cloth of our nation go into harm's way without hesitation. It is our duty to take care of the repercussions of such selfless service. This is one more example of military toxic exposures causing adverse health conditions which have been ignored for far too long. The VFW also thanks the committee for its attention in numerous roundtables on Inuit Atoll and for fighting to secure those veterans the benefits they deserve. The VFW supports the Veterans Valuing Our Widows and Widowers Act, which would transfer the Medal of Honor pension to surviving spouses. Medal of Honor recipients have made extraordinary sacrifices for our country and are rightfully awarded a special pension for their heroic acts. Their loved ones often forego careers to become full-time caregivers. This means they become dependent on the Medal of Honor pension to make ends meet. However, the Medal of Honor pension ends with the death of the recipient, and their surviving spouses often do not qualify for VA benefits upon their death. The VFW also supports the draft legislation to establish a grant program to conduct cemetery research and produce educational material for the Veterans Legacy Program. Perpetuating the life and memory of our fallen is one of the VFW's founding principles. The Veterans Legacy Program ensures that the memory and stories of the brave men and women buried at the national cemeteries are preserved in perpetuity. The VFW is a strong supporter of this program and has worked with the National Cemetery Administration to improve and expand it. Madam Chairwoman, this concludes my statement. Happy to answer any questions you or the members of the committee may have.
Thank you, Mr. Fuentes. I would now like to call on Mr. Weidman from the Vietnam Veterans of America for 5 minutes.
Thank you, Madam Chair and Ranking Member Boss. The VVA strongly favors passage of 299, and I often forget it because most of the time I don't need a mic, but I understand it's for the record. This legislation is so long overdue that we can hardly stand it. As you know, our membership is comprised exclusively of Vietnam veterans. So this is an issue that is very hot with us. We need to clear up the wrong that was done in '97 without a shred of scientific evidence, I might add. We always have to come up with evidence that is compelling, but the VA removed us from the Blue Water Navy veterans from the Agent Orange Act of 1991. Now, the intent of the 91 Act, and we know what we're talking about because we worked with on this side, it was Lane Evans, and on the Senate side, it was Senator Daschle. to get that bill written, and it was written and envisioned as to include everybody who served in the waters off Vietnam. Not a particular coordinate, not a territorial seas necessarily, but anybody who served in the waters off Vietnam. The scientific evidence is in fact there. The 2011 National Academy of Medicine report is crystal clear that it was there. The only reason why they didn't kick it up a notch, if you will, was they said they didn't know how much each person was exposed. So we asked, we meaning AUSN, Association of the United States Navy and Fleet Reserve, asked the chair of that panel, well, doctor, can you explain to us what is a safe dose of dioxin? And her comment back was what we already knew, is there isn't a safe dose of dioxin. A harmful dose was at that time defined as 7 parts per billion. It's now 5 parts per billion. And when they reviewed the science having to do with Blue Water Navy, they found that we were absolutely correct, that the desalinization units picked it up and concentrated the dioxin in the water many times, up to 100 or even more times over, making that anybody who drank water on that ship or anybody who ate the food that was prepared on that ship was in fact ingesting a significant dose of dioxin. And remember that it was happening every day for months. So the scientific evidence is there. In terms of moving forward, we continue to have the position at VVA that if you were awarded the Vietnam Service Medal for service in a service ship, in a surface ship, and off Vietnam, then you should be in. We would also urge the committee to press the Secretary for implementation of the reports that have been pending and the recommendations on additional presumptives. It's been 3 years now, and it needs to get done. All of the stuff with Agent Orange, I would remind the chair and all present that the mean average age of Vietnam veterans will be 73 come June of this year. The median age is a little bit younger. It's about 71 point something. But because of what our exposures, people are dying early. And all of the presumptives and this group of people who have been harmed with toxic wounds needs to get taken care of. The last thing I want to say, even though there isn't a bill on it, is the committee needs to be keenly aware that the so-called registries VA has are not registries. They're simply email lists or mailing lists for snail mail. What we need is a real registry where you can follow the health of people by coding their electronic health care record. While we wait for the new EHR to be implemented, that could take 10 or 15 years. What we need, you have 3 blank fields on the current EHR in use at VA. With 3 blank fields, 26 letters, and 0 through 9, you can come up with many hundreds of codings. So where somebody served, what branch they served in, and their MOS, all can be coded so that you can find out and do epidemiological work. That is exactly what the National Academy of Medicine was saying over and over and over again for the last 20 years, is the VA and DOD do not mine the mountains of data they have on every doggone one of us. And I encourage the full committee and this committee to require VA to do that coding and start it now using the existing system. I thank you very much for your patience and for your attention to these important matters today. Thank you.
Thank you, Mr. Weidman, for your statement. I would now like to turn to Mr. Nudavong from the American Legion. You are recognized for 5 minutes.
Thank you. This year, Nina would have been married to U.S. Army Sergeant First Class Augusto Tito Pinero for 10 years. They have 3 children. But on October 9th, 2017, Tito was riding a bicycle around 7 a.m. when he was struck by a vehicle heading in the same direction. He died at the age of 38. Chairwoman Luria, Ranking Member Bost, and distinguished members of this committee, on behalf of National Commander Brett Rystad, representing 2 million dues-paying members living in every state and American territory, it is my duty and honor to present the American Legion's position on pending legislation being discussed here today. Shortly after Tito's death, he was cremated. His family plans on burying him in a private cemetery in Florida. This non-VA cemetery is a site where Nina intends to join her husband. However, current law does not allow the VA to add information about spouses and/or children to government-furnished gravestones or markers in a non-VA cemetery. Including family information on headstones and markers is a standard custom in our society. Families of veterans should not be any different. H.R. 1126 is a common-sense bill that ensures veterans and their family members receive the support and recognition they deserve. For over 100 years, the American Legion has advocated on behalf of our nation's veterans, including the awarding of disability benefits associated with chronic medical conditions. Annually, veterans and their families are subjects in a debate regarding the cost of living adjustments. For these families, COLA is not simply an acronym. It is a tangible benefit that meets the needs of increasing cost of living in the nation that they defended. The proposal in H.R. 1200 is simple, Madam Chair. This bill will increase compensation and pension benefits to those who need it most. In this year's landmark Procopio decision, the Federal Circuit ruled in favor of blue water veterans. Yes, they were exposed to toxic herbicides. Yes, service in Vietnam War extended from the coast out to the sea. And yes, VA must begin granting claims of veterans who suffer from the conditions set forth as presumptive under U.S. Code. We are pleased that VA Secretary Robert Wilkie told the Senate that he would not ask the Department of Justice to appeal the decision, and we believe that Congress is doing the right thing for our blue water veterans and their families by enacting into law what the Federal Circuit was decided and what VA said it would not oppose. There should be no changes to other veteran benefits because Congress is implementing a court's decision. Congress should enact into law the broadest definition possible and provide clarity and guidance for the expected VA regulations implementing Procopio, and thereby potentially avoiding further legislation over the definition that might needlessly delay the approval of VA claims. Our veterans and families deserve no less as they have waited patiently for more than 44 years. And we believe VA should begin to act even before H.R. 299 becomes law. Like their Blue Water colleagues, service members cleaning various nuclear testing sites during the 1970s and 80s were exposed to significant toxic exposures because of their duties. These individuals who participated in cleaning up these nuclear testing sites suffer from high rates of cancer due to their exposure to radiation and nuclear waste. They are currently unable to receive the same treatments and service-related disability presumptions that other radiation-exposed veterans receive from the VA. The American Legion believes that these veterans deserve the same benefits that U.S. law guarantees to other service members impacted by their toxic exposures. And we believe that VA should be responsible for the care of these atomic cleanup veterans. We support H.R. 1628. Ladies and gentlemen, let's give America's sons and daughters the benefits they've earned. We thank Chairwoman Luria and Ranking Member Bost for their incredible leadership and always keeping veterans at the core of their mission. It's my privilege to represent the American Legion before this committee. I look forward to answering any questions you may have.
Thank you for your statement. I would like to now turn to Mr. Learman from the Disabled American Veterans for 5 minutes.
Thank you. Chairman Luria, Ranking Member Boston, members of the subcommittee. On behalf of DAV's more than 1 million members, we thank you for the opportunity to present our views at today's legislative hearing on the Subcommittee of Disability Assistance and Memorial Affairs. In our written testimony, we address all 7 bills of concern for today's hearing, and I refer to our statement of record. This afternoon, I will be primarily focusing on the amendment and the nature of the substitute to H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2019. DAV strongly supports the amendment, which will help correct the injustice done to Blue Water Navy veterans. When VA implemented the Agent Orange Act of 1991, they determined that veterans who received the Vietnam Service Medal, to include those who served in the waters offshore, were exposed to Agent Orange. In 1993, a VA General Counsel opinion held that veterans with service in the waters offshore were exposed to Agent Orange. In 1996, Congress passed the Veterans Benefits Improvement Act, which extended the official wartime period service in Vietnam. However, a subsequent VA General Counsel opinion in 1997 misinterpreted that statute and determined only veterans who physically served in Vietnam would be granted a concession of exposure to Agent Orange. This is the precise moment when the VA started to explicitly exclude Blue Water Navy veterans and negatively impact their access to VA health care and service-connected benefits. And then again in 2002, the VA updated its manual reiterating that exposure to Agent Orange was conceded only to those physically in Vietnam. So to clarify, from 1991 to 1997, veterans with service in the waters offshore of Vietnam were considered to have been exposed to Agent Orange, as Congress intended. The decision to exclude Blue Water Navy veterans was not based on any medical or scientific evidence, law, or congressional intent. It was based solely on their misinterpretation. In 2006, the Court of Appeals for Veterans Claims held that VA's interpretation was incorrect. However, VA subsequently appealed that decision to the Federal Circuit. In 2008, the Federal Circuit gave deference to the VA's interpretation, which continued to exclude Blue Water Navy veterans. As you know, during the 115th Congress, Blue Water Navy legislation passed the House with a vote of 382 to 0. However, the bill was not successful in the Senate. We are pleased that Chairman Takano and Ranking Member Rowe have collaborated to bring H.R. 299 back before the committee. On January 29th, the U.S. Court of Appeals for the Federal Circuit in Procopio v. Wilkie overruled VA's previous misinterpretations and determined that service in the Republic of Vietnam includes the territorial waters within 12 nautical miles of the baseline. H.R. 299 would protect Procopio's holdings that service in the Republic of Vietnam includes the territorial waters. This bill would use the same grid coordinates in the legislation approved by the House last year, which would extend beyond 12 nautical miles in some locations, particularly in the Mekong Delta. We strongly support H.R. 299 as it is in alignment with DAV Resolution 33, which advocates that service in the Republic of Vietnam includes service in the territorial waters. Tens of thousands of veterans, their families, and survivors have been denied their earned benefits for decades. While it is way past due, it is time that we correct the injustice done to Blue Water Navy veterans and provide protection of the Procopio decision by passing H.R. 299. In closing, Madam Chair, I would like to note that H.R. 1200 would authorize a cost of living adjustment for veterans in receipt of compensation and pension, and for survivors of veterans in receipt of DIC, and provide an increase by the same percentage of Social Security effective December 1st, 2019. DAV supports H.R. 1200, and we are pleased that it does not include any language about rounding down the proposed COLA increase. This concludes my testimony. I would be pleased to answer any questions you or members of the subcommittee may have.
Thank you. I would now like to call on Mr. Butler from the National Academy of Sciences, Engineering, and Medicine for 5 minutes.
Chairman Luria, Ranking Member Bost, Chairman Takano, Ranking Member Rowe, thank you for the opportunity to testify today. I'm here in my capacity as a scholar in the Health and Medicine Division of the National Academies of Sciences, Engineering, and Medicine, and as director of its Office of Military and Veterans Health. Accompanying me is Dr. Arani Acosti, Senior Program Officer in the National Academy's Nuclear and Radiation Studies Board, and Principal Investigator for the Radiation Effects Research Foundation Program, which provides support to a cooperative Japan-U.S. research organization that studies radiation effects in survivors of the atomic bombings of Hiroshima and Nagasaki. The National Academies has a long history of advising the federal government on the health effects of radiation exposures in general, and in radiation exposures resulting from military activities in particular, work that began in 1946 with a directive from President Truman. Since then, among other efforts, we have conducted reviews of the methods used to assign radiation doses to service personnel at nuclear weapons tests, an examination of the use of film badge dosimetry in atmospheric nuclear tests, studies of the mortality of military participants in U.S. weapons tests, and in 2003, a comprehensive review of the dose reconstruction program of the Defense Threat Reduction Agency. The National Academies has also previously done dose assessments generated by the federal government for personnel exposed to radioactive materials as a result of their work in the Department of Energy's Hanford, Fernald, and Savannah River nuclear weapons production facilities. The Office of Military and Veterans Health that I direct has analyzed data on the causes of death of participants in the Operation Crossroads atmospheric nuclear test series that took place in the Bikini Atoll in the Marshall Islands. I've included a list of National Academies reports related to ionizing radiation exposure and radiation dose reconstruction in the materials submitted for the subcommittee's reference. Turning to the legislation in consideration in this hearing, H.R. 1628 outlines the parameters of a study that would allow for more complete understanding of the radiation doses received by those involved in the cleanup operations undertaken at Inuitak Atoll from 1977 to 1980 in response to nuclear testing in the areas in the 1940s and 50s. It takes as its starting point a 2018 Defense Threat Reduction Agency dose assessment for military personnel involved in cleanup operations. A radiation dose assessment, which is also called a dose reconstruction, is in brief a means of characterizing a person's received ionizing radiation dose through an accounting of exposure scenarios, exposure pathways, and uncertainties. Depending on the available information, a dose assessment may include some combination of direct or indirect measurements obtained, for example, by film badges or field survey instruments, and estimates of unmeasured parameters that are based on historical data, along with proxies for exposure, such as a subject's job and a subject's recollection of the tasks that they performed, the physics of radioactive materials, and human biology and physiology. A radiation dose assessment often entails the calculation of the estimated upper bound dose, that is, the dose that would occur if all the uncertain elements of the analysis were set to the plausible value that would, in combination, yield the highest estimate. The proposed study would address two primary questions related to the Inuitak veterans: whether information exists to conduct a revised or alternative radiation dose assessment that would consider exposures and exposure pathways that were not part of the 2018 radiation dose assessment, and whether conducting such a revised or alternative dose assessment is feasible and be likely to yield a substantively improved estimate of the radiation dose received by those who participated in the cleanup. If the answers to those questions were yes, the study would go on to identify the sources of data for the new assessment, including a delineation of the assessment protocol, estimate the time and funding needed to conduct the assessment, identify the assessment's major sources of uncertainty and how such sources may affect the estimates generated, and identify the best means to carry out the new assessment. The National Academies believes this is a scientifically sound approach to addressing lingering questions regarding the exposure of Inuitak veterans, and that the results would allow veterans, their loved ones, and the federal government to make more fully informed decisions. Thank you for your attention. Dr. Costi and I would be happy to answer your questions.
Thank you very much to all of you for your statements. And I now recognize myself for 5 minutes for questions. I'd like to start with discussing the Blue Water Navy Act, HR 299, with the different VSOs that are present. And you can jump in, or if someone particularly wants to speak more than once on the same question, feel free to let me know. What are the current issues facing an aging Blue Water Navy population who seek disability benefits from herbicide-related diseases? Can you list, some of the main health factors that they're experiencing and what's most prevalent among this population?
Really what it comes down to is they're sick and dying from the 15 conditions that are scientifically linked to Agent Orange. They really don't have the benefit of time, as Rick explained, and have been denied benefits for far too long. So we can't delay any further.
VA hasn't tracked what kind of illnesses Blue Water Navy has. Australians, they first discovered the anomaly that the Navy vets, the Australian Navy vets, had higher cancer rates than the ground pounders. And so they commissioned the University of Queensland to look into that, and they went back and studied what was going on. And they discovered that it was through the desalinization units that their sailors were being poisoned, and because the desalinization units concentrated the dioxin many times over, they were getting cancers of the digestive tract mostly, on much higher incidence than even the ground pounders. So VA, for a long time, claimed that Americans' ships did not do the desalinization using the same theory. Well, it turned out that not only did we do the same theory, it was the same units manufactured by W.D. Burroughs and Son and installed on the American ships and installed on the Australian ships. So the history of mendacity, misleading, and confusion, shall we say, deliberate confusion, goes back a long way when it comes to Blue Water Navy. And it's just time to do it. Their families are suffering, etc. And it's time, and I thank you very much for moving forward on this issue.
I agree with you wholeheartedly that it's time that we take action on this and we provide the benefits and the health care that these veterans deserve based off their service. I'd like to shift now to hear from the various VSOs. Do you think the VA is adequately prepared to begin providing disability compensation and health care benefits to Blue Water veterans? And once this change happens by hopefully enacting the HR 299, what do you think are the biggest barriers to making sure that people who've not previously received that care or that recognition of a service-connected disability or illness are going to have seeking that care?
They're not, at this moment, they're not. But to their credit, Undersecretary for Benefits, Dr. Lawrence, has reached out to us to plan a way forward. And frankly, the biggest challenge is to make sure that those folks who have been denied benefits and were denied in the past, and even their survivors, really are made whole and in a timely basis. So we don't want backlogs, and it's a way to get it done, and we'll work with VA to do so.
I think one of the biggest problems they're going to be facing is from a development point of view. When the veteran establishes a claim, it goes through the development process before it goes to a rating RVSR to make a decision on the case. And for them to try to get the information on the location of the ship, was the veteran on the ship at the time it was exposed, that's probably going to be the biggest piece of this that has potential to slow it down. DAV has also made recommendations to VBA that they should have started this process several months ago to help alleviate it when we get to this point, because that really is going to be, I think, one of the biggest hurdles, not making the decision once they've determined if they were exposed and they have a disease. That's actually the easy part. The hard part is going to be the development into determining where were they and were they considered exposed.
Thank you. I can imagine it'd be quite a complex thing, tracing back through, deck logs and service records and determining dates of, where ships were located at specific times. So I see it as a complex task to identify this information for each individual veteran. So I agree that, you know, the groundwork should be started as soon as possible to make this more smooth. And, you know, you've referred as well to some of the veterans who've been denied in the past. So I assume that many of these are known cases, yet there are some that are not known because people haven't potentially presented themselves in the past in seeking a claim. So how will you as VSOs seek to communicate and find these other individuals who may not have yet, you know, come forward thinking that potentially they could have, you know, been eligible for this benefit?
They need to pull the ship's roster and deck log and computerize them. It's not hard. And frankly, we're just not talking about that many ships. We made that recommendation, and I think a number of our colleagues represented here made the same recommendation to the VA 2 months ago, just in case. And if I was a betting man, I would bet that one of the reasons why they wanted to reserve the right to appeal at an extra 90 days is to get set up. We also suggested they choose 5 regional offices, not some of the biggest ones, and immediately start staffing up there for regular claims and train those staff as to how to do these claims. And whether they've done it or not, I do not know, but we have recommended it repeatedly.
Thank you. I think I've gone over the time, so I will now call on Ranking Member Boss.
Thank you, Chair. Dr. Butler, some veterans have voiced concerns that the method DOD used to estimate the potential dosage of radiation exposure at EventID cleanup veterans was unreliable or outdated. How would the NAS study under HR 1628, the EventID et Cleanup Radiation Study Act, differ from DOD's investigation in 2018 on radiation assessment, assessing the amount of dosage that they receive?
Well, if the National Academies were asked to perform the study, we'd form an expert committee that would evaluate the DOD radiation assessment report. That committee would examine the data and assumptions that went into the assessment, determine whether there were any gaps or alternative ways to characterize the exposure and manage the uncertainties involved. To draw its conclusions, the committee might review a sample of individual dose assessments that were performed and evaluate those. That was the approach that we took in our 2013 review of DOD radiation dose assessments. Very importantly, we would look at how uncertainty was being factored into the analyses. If the committee identified alternative or additional data or ways to more completely assess the doses, then it would offer recommendations on how to improve the assessments. For example, it might recommend that sampling be done from the veterans themselves to determine whether there are measurements that could inform a better characterized exposure assessment.
So it's been 40 years since the cleanup. So how would you estimate, after 40 years, how in the world do you get back there and figure out, okay, this person was exposed to this much, or how do you do that?
For that question, I'd like to defer to my colleague, Dr. Costi.
Thank you. So indeed, any dose reconstruction relies on data and information that was collected in the past. So we will rely on badge measurements that were done in the past, field measurements, recollection of the veterans of where they were, what kind of tasks they were doing at the time. So all this information is past-looking, and it has its uncertainties, inherent uncertainties. There are ways to do better analysis today or to inform and add information to what already exists. And Dr. Butler measured one of those by taking current measurements today with the consent of the veterans.
Okay, thank you. Mr. Weidman, can you please briefly describe VVA's belief that Agent Orange presumption period for veterans who served on or near Korean DMZ should begin on September 1st, 1967 instead of April 1st, 1968?
Because we believe that Agent Orange, frankly, was used wherever American troops were. It's just as simple as that. And incidentally, that's not limited to the DMZ in Korea. We believe they were used every place we had a military base, certainly in the Pacific, but also many places in the United States, like Edwards Air Force Base in Florida, etc. Most of those are not recognized. And frankly, the track record of being forthcoming on the part of DOD is not thrilling, shall we say. So more needs to be done with your colleagues in the Armed Services Committee in digging into it. Thank you.
Madam Chair, I yield back.
Thank you. I now call on Chairman Takano for 5 minutes.
Thank you, Madam Chair. Mr. Weidman, I'm going to ask each of the VSO representatives to just answer a simple question. Take about a minute to do it. Can you tell the committee how important it is for your members and our veterans that we get H.R. 299 passed into law?
Extremely important, top priority.
Mr. Fuentes.
It's the #1 issue we hear about today.
Mr. Nuttavong.
We are extremely, it needs to get done, Chairman.
And Mr. Learman.
Yes, thank you, Chairman. Out of our over 1 million members, over 480,000 of them are Vietnam-era veterans. So this is a big priority and very urgent for our membership.
You can go a little further than a couple of words, but just kind of give me the committee, the urgency.
I've been representing veterans for DAV for about 21 years. I've been representing them at different VA regional offices and the Board of Veterans Appeals for 5 years. And I can say this, it's a horrible feeling when you have to tell a veteran that no matter what we do, they are not going to be eligible for that presumptive because they were on ship. They weren't in country. Unfortunately, we've had that experience over and over and over again over the last 20 years because they're not being allowed. Those veterans are dying. Their survivors are not entitled to those benefits that they should have been. So explaining it from that point of view, from the service end, we see it continually every day, not just with our members, but the veterans and their survivors that we represent. And there's got to come to a point where it's just got to stop.
Thank you.
Mr. Chairman,
go ahead, Mr.
Chairman, if I may add, we also talk to veterans every single day dying from rare cancers, prostate cancer, and these illnesses that are directly connected to Agent Orange. And the issue with not having presumptive is you're actually asking a veteran to go back past 50 years and present some type of evidence that shows that they were directly exposed to Agent Orange, or the ship that they were in this case, was in contact with Agent Orange. Now, I'll tell you, I was in Afghanistan in 2009, and I could never be able to present to you any evidence of where I was at and exactly what I was exposed to in 2009, and can't even fathom how hard that is for Vietnam vets.
Basically, if it's not on the presumptive list, you're not going to get a grant at the regional office level. Often you will get it on appeal to the board if you have a good representative who builds a thorough case. But it shouldn't have to be this damn hard because we know people were exposed.
Men and women are dying every day, Chairman, and every day we wait is another veteran who may pass away from a presumptive that is not being granted to them currently. We can't wait anymore.
Madam Chair, I yield back.
Thank you. I now recognize Dr. Rowe for 5 minutes.
Thank you, Madam Chair. Look, we obviously know what the will of the House in the 115th Congress was, and I think you're going to know the will of the House in the 116th Congress. And by the way, Rick, you're correct. You do not need a microphone. I will say that. I hear you loud and clear. So we know what that is, And I'm with you guys. It's time to quit talking about this and get this done. And I don't have anything more to say then, and that my frustration level is about here. We've talked this to death. We've found a way to pay for the Agent Orange exposure. We've done all the things anybody asked. The president will sign this into law in 2 seconds if he can get this in front of him. So let's get this done. And I appreciate the chairman. I think he has been right there with us the whole way. I thank you for that. And I know he's committed to get this out of our committee before Memorial Day. I think if we can find I'll yield to the chairman.
Dr. Rowe, with your support, and I know I have it, we are going to get this done by Memorial Day. And you and I and all of the folks at the table, we will go to the Senate in person if we need to and stand in the gallery every day until the Senate brings this to the floor and gets it voted out.
Thank you, Mr. Chairman. I absolutely believe this. I think if you can get it on the Senate floor, a cloture vote's not going to be a problem. And I think you'll see 90 votes in the Senate. So it's procedural. Carlos, I agree with everything you said. It's time to move on, get these benefits to these veterans when 500 plus of us are dying every day. We can wait it out and we'll all be gone in not too long. So if you do that, I think it's shameful that we didn't get it done last time, and it's shameful we're not doing it right now. Madam Chair, I yield back.
Thank you, and I'm grateful to all of you who participated today in the 4 panels, and also for Chairman Takano, Ranking Member Rowe being here from the full committee as well to speak on this very important issue of the Blue Water veterans. I also wanted to thank the representatives from the VA. Appreciate that you stayed throughout all of the testimony and also heard how important this issue is for the Blue Water veterans, and hopefully you will take that back to the Secretary and your leadership, what we discussed in this hearing today. Lastly, I would also like to thank the committee staff. I know that it took a lot of work and effort to bring this together and to bring all of our witnesses before us. And I think, Chairman Takano, you motioned
Just real quick, Ranking Member Rowe, I just think it's just serendipitous and so appropriate that this hearing is being presided over by a Navy veteran, the first woman Navy veteran to actually serve on our committee, and that she commanded naval surface ships, and it just seems very appropriate to me. So thank you so much for your service, Ms. Luria.
Well, thank you, and I would also like to offer the opportunity for Dr. Rowe if you'd like to make any closing remarks.
Just very briefly, and Carlos, once again, I couldn't agree with you more. There's no way on this earth I could prove where I walked around in Korea 40-something years later. I mean, I wasn't even sure where I was walking around at the time, much less 40-something years later. So I agree with you. We're just going to have to make some assumptions. We have data, as was pointed out, about who was on which ship. Let's get on with it. And I'm ready to do it. I know the House is ready to do it. I think the Senate, I really do appreciate, more than you know, the shoulder that the VSOs have put behind this effort. I know it's been frustrating for the last 20 years to get these benefits to these men and women who served, and I salute you for that. I yield back.
Well, thank you, and thank you again to everyone for your time and for participating in the hearing today. All members have 5 legislative days to revise and extend their remarks and include any extraneous material. So thank you very much, and this hearing is adjourned.